Hello friends, welcome to the world of insolvency. This is your mentor, faculty, professor, or your friend C. Naveen Khandelwal from Indore, who will be guiding you to this world of IBC 2016 over the next 5 hours. And this presentation has been specially developed for the Indian Law School and their students. So let us understand that why IBC came into this world. What was the reason behind that? And what was there before this particular law was introduced? And then what are the intricacies and the complexities involved in the various sections of IBC 2016? And then we'll deliberate and understand each of the sections. And then we'll study certain case laws, relevant case laws, which have been, pronounced by the various courts, including the Supreme Court. So let us start our journey for this world of IBC. And let me difference what a way we are living our life in the current situation. Though the year is 2020, but life is going like a test match, isn't it, friends? So let us enjoy this test match, and probably it is a strategic timeout for all of us, and where we will try to improve our knowledge and capitalize on this particular time period to develop a new skill set for all of us. Before we go ahead and understand that how things are shaping up, friends, very important, before we get into the world of IBC, let us pay a small tribute to two of the finest actors of Bollywood. I'm a big fan of Bollywood, friends, so that is why I thought that what better way just to give a tribute to this person who has been a person for all medium friends. And he has said in one of his movies, "Ek baar to yun hoga, thoda sa sukoon hoga, na dil mein kasab hogi, na sar mein junoon hoga." And that is the actual life which we are realizing and living at this particular point of time, where there's nothing in our mind, just doing nothing, right? And another person whom we should give credit to, who has contributed a lot to the Bollywood, is friends Rishi Kapoor. And iska bhi bahut bada qarz hai to this Bollywood industry. And he has said in one of the movies that pyar karne wale adbar ka certificate nahi mangte. Though in relationship certificate is not required, but when we appear in the court and various other forum, I think we require a certificate. And that is why we are here, to gain that knowledge, friends, isn't it? So before I start, let me put a disclaimer, friends. All the views represented here are my personal, and they do not in any way represent the organization owned or controlled by me. Probably it is a very standard disclaimer which always should be there in all your presentations and whenever you come on a public forum and discuss the various aspects of law. So I think we all understand, being a future professional people and lawyers, I think we all understand the importance of giving a disclaimer before any lecture starts. So is insolvency a good or a bad thing? Though the word insolvency does tell us that there's something bad about this word, but let me tell you, friends, I think the word insolvency has got much wider scope than the word itself, what insolvency says. Insolvency is not purely related to something bad which is happening to us, but it also relates to giving value to all the stakeholders. And to give you an example, friends, this person, the Honorable President of the United States of America. And when you study his background, you will come to know that in the last 20 years, many of his companies which belong to his domain, his area, they have filed for bankruptcy in the United States of America. So is it a good thing or a bad thing? Friends, let me tell you, insolvency is always there to promote businesses, to develop that ecosystem where people, business owners will feel comfortable in starting a business, and they know that the end is also there where they want to come out of the business. That is a possibility, which probably did not exist before this act came into picture, friends. So insolvency is also a part of the integral part of the whole business cycle. Remember, this whole business cycle, which starts from entry to the insolvency plays a very important part in ending of the business. So world across, insolvency and bankruptcy is always taken in a positive manner rather than the negative aspect of the business world. So why IBC? Again, just to reiterate that same point that it is a positive aspect. Let us understand and go back to history and let us see the framework why this IBC came into existence. So it started in 1991, where we all know that India opened up its business economy through its LPG policies, liberalization, privatization, and globalization. Because of this, what happened? Probably all the businesses got an easy entry to the world of Indian business, Indian economy. But then, yes, a lot of businesses thought, yes, the entry became easier. But then what about the fair play? The business who were running in India, they could feel that, yes, there's not such an even playground where everybody could come and do the business properly based on the normal ethics and code of conduct of doing business. And therefore, in 2002 came the Competition Act with a lot of changes in the previous Competition Act. So there was entry relaxation. People got easy entry to doing the business. Then they got a fair play of running the business. But then people thought, yes, entry and fair play is fine. But what about the exit part? If I want to sell my business, if I want to go out of my business on my own, then is it a possibility? Yes. Then came IBC 2016, where the exit was also made easy. So if you see the whole domain, whole ecosystem, whole environment and business cycle, entry, fair play, and exit, when all three get clubbed, probably the ease of doing business becomes more easy. And that is why the ranking of India over the last 5 years has gone up, because of the obvious reason that the ease of doing of business in India was relaxed, and people could find it from the entry till the exit. There are certain laws which are framed, and they all give a particular comfort level to the owners of the business. That is why IBC was born in 2016. Let us move ahead and understand that what is IBC. If you break that word, as we all lawyers do, we have a habit of breaking the words of the section. So what I have done, we have broken the word IBC into three parts, that is insolvency, the bankruptcy, and the code. So insolvency is basically a term where I'm incapable to pay the debts. I'm incapable, right? That means my business is not running properly, so I term it as incapable. Bankruptcy relates to where there's an inability to pay debts. So inability, that means I don't have the sufficient assets to pay off my debts. And then there's the code and not the act part. A code which says that, which subsumes various other insolvency laws and act as a single window solution. So that is the meaning of IBC. So the question comes in, a natural question which should come to every student, friends. When I mentioned that it is a code, why it was not an act? So let me tell you, friends. A code is something, legally what code is. Code is something where it subsumes lot many other acts which were prevalent before the introduction of this particular code, and all those portions of the previous acts which were relevant have been included here with a single window which will cover all the important sections and provisions of the other act. While an act is purely an independent part which basically focuses on a particular aspect and it is not covering other laws. That is why IBC just subsumed lot many other acts, therefore it is referred to as code and not an act. So if you see all these subjects where you have studied the Civil Procedure Code, the Indian Penal Code, now you understand that what was the purpose of naming it as a code and what are the acts. So what were the acts which are now subsumed in this particular IBC world? So before this IBC came into picture, friends, I think there were a lot of other acts which were prevalent, which which measured the way how company could go for insolvency. So there was the Companies Act 1956. Thereafter, 2013 came in. Then there was the SICA Act 1985. Then there is a recovery of debt due to banks and financial institution friends, where if the focus is on recovery of debts from all the borrowers. And the most common one is this, which is again very common, and they are used by the bankers to recover the amount from all the defaulter borrowers. And then there was the BIFR Act, right? Board of that was a board basically which looked after the SIC companies. And then there was the old Presidency Insolvency Act 1909, which is again was relevant till IBC came into the picture. And then you will find it, there are different circulars and notifications and directions received from RBI at different point of time, which highlights, which tells us or gives guidance to what should be done in the case where the company is not doing good, company is classified as an NPA, company is a default. So you see that there were a lot many acts which were covering all these aspects of insolvency and bankruptcy. And what IBC has done, they have taken all the important parts of this all different acts and clubbed it under one act, that is Insolvency Bankruptcy Code. Out of all these, there are some acts which are still there, like the SERFASI Act, which are still there, but some of the acts have been repealed and they do not have relevance today. Then the purpose of IBC is to what IBC aims to, there is one aspect which we understand, that it was like to give you the ease of business to all of people. Now the question comes in, that what is the basic objective other than the ease of business, friends? So the objective comes in, friends, is to promote entrepreneurship. Now you will ask, sir, how entrepreneurship is related to insolvency? A very valid question. Yes. So let me tell you, friends, when an entrepreneur starts the business and he knows that, I have an entry point and I have an exit point also, probably it gives him the satisfaction and the courage to start a business. And that is why insolvency is regarded as a mode to promote entrepreneurship. Then to make credit available, and that is the availability, that is the obvious reason, that credit available to whom? To all those people who are not in, and probably IBC offers them a medium to run their businesses on their own or by someone else, and to make the finances available. And to balance this interest of all the stakeholders. Now, when you run a business, there are so many stakeholders involved, right? From the equity owners, the people who have given loan, people who supply material services, and then the government is there. So there are so many stakeholders. Stakeholders probably have to follow a different mode to recover the amount in the pre-IBC area. So the interest of all the stakeholders, including the laborers, the employees, the workforce, has been taken care in this particular act, and appropriate place has been given based on the nature of services provided to the corporate world. One of the most important feature here is, friends, remember this fourth point is very relevant, and probably this puts the IBC code as always on the top in comparison to the other laws, is that it brings in a time-bound resolution for maximizing the value of the asset. Where, if you do a research and study of all the companies which have gone into liquidation in the last 20 years, you will find that it took about around 7 to 9 years for a company to wind up. And then within that span of 7 to 9 years, the value of assets keep on decreasing. But here in IBC, because it is a time-bound resolution of 180 or 270 or maximum 330, which is given in the law, that means the objective is to maximize the value of asset, and they could be sold off at the right time, rather than waiting for 7 to 9 years to bring out a resolution or dissolving the companies. So IBC, in terms of time frame, really overpowers the other act, and that is why a lot of people are thinking that IBC is a proper solution to the whole ecosystem of a business, because of this particular fact of time bound. Then we all understand, and as explained in my previous slides also, that the law is covered, is giving us a consolidated framework for insolvency and bankruptcy, dealing with, the corporate, the partnership, and the individuals also. And to enable the, and probably this is only one law which will cover all the of the business, all the entities of business, which is very important. Otherwise, everybody has to follow a different law. It makes things difficult. So very important, this law gives a consolidated framework for IBC for all the level of entities. And the last one, probably it's a complex thing to be understood at this particular point of time. But yes, I think IBC thus creates a robust debt and bond market where a lot of people who have given loan, given a certain amount of money for a business to run, and probably when the business is not running, and then the debt market to a tinker, it goes down because that company is into default. Probably because of this IBC, it gives some certain kind of stability to all those bond market, where even if company is a default and is not running properly, probably people will know, the market participants will know that there is a possibility of bringing out a resolution for this particular company. That is why the bond market will stabilize, and that is why it enables the functioning of a very robust and a deep and intricated bond market. So this was the background and the purpose of this particular insolvency law. So having understood the background and the purpose, then in my next part, I will try to cover the IBC law as an overview, right? I'm not going into details first, but then first we'll understand the overview of this IBC law, and then we'll start with the respective relevant sections and provisions of IBC.